Sorry, my phone dropped.
Your full name?
Are you talking to me?
Yes. Yeah. Could you just state your full name, please?
Okay, well, I think you've rung Caitlin Fiona McDonald.
Thank you. Caroline James.
Dominic James Grant Clapham.
Courtney Grant. Thank you.
All right, well, good morning, everyone. My name's Mr. Woodhouse. Now, sorry, madam, what was your surname?
Register.
Register. Lovely. And, madam, your surname? Brown. Lovely. All right, well, get yourself settled there, folks. All set to go? All right. Well, good morning to all of you. So, as I said, my name's Mr. Woodhouse. I'm the adjudicator. We've got two matters to be determined. I'm going to begin by clarifying what the issues are that I'm going to adjudicate, because they're actually far more simple than both parties. Okay. Appreciate it. There's only two issues. First, whether or not a rehearing can be ordered in relation to the tribunal's order from the 2nd of May 2023, and secondly, whether rent arrears can be ordered, and that's it. Mr. Clapham, I've read your submission seeking exemplary damages, and they cannot be ordered for these reasons. What you say is that exemplary damages are sought on the basis of the application 4402060. Now, that order does not adjourn the hearing. Well, the order from the 2nd of May does not adjourn the hearing to consider exemplary damages at all. It was a final order. So if you thought that exemplary damages had been missed by the adjudicator, then you either needed to file an appeal or a rehearing. But because no such application was made, the decision's final, and that's it. So the only thing which remains in relation to that particular application is the rehearing request from Ms. McDonald, and we're going to hear that today. So the only other thing, of course, is the rent arrears, and we'll get on to that. That should be a relatively straightforward matter too.
It is,
Any
yeah.
questions before we get going?
Yeah, so I sent Jenny through 5 requests that I asked her to send to you, and they're entirely up to you whether or not you want to grant those requests. But the first one was that I did ask if you could ask the parties to tell the truth, and I think I unfortunately, for personal reasons lately, I was not able to show the proof that the parties have lied, but I don't think it's going to be a very difficult or onerous process for you just to ask the parties to tell the truth, because that gives me recourse under section 111. Now, I'm not asking you to take an oath. That was previously mistaken by Robin Merritt. I'm asking you under section, I can't remember what section it is, if you would just ask the parties to please tell the truth.
Yeah, you said there were 5 things. That was the first one. So what's the next thing?
I'm sorry, I don't have it in front of me. My computer's being a bit funny and I didn't print everything off. But look, either Jenny put it on the file or she didn't. But it's with Jenny.
All right. Well, the problem is, McDonald, there's so much communication.
Okay, I can remember another one. No, do you know what? It's really up to, I think, the tribunal. The tribunal has given the registry the discretion to put things on or off the record. Now, the requests I've made are thoroughly well reasoned, and it's quite clearly indicated, and it was quite recent, so I don't think it's going to be much trouble for Jenny to pull those questions up. But they all indicate for me quite good recourse, because as you may or may not know, I do not regard this as a hearing because section 91 has not been met whatsoever for the matter of what is it? Which is the one that I asked for a rehearing of. It's just been a dog's breakfast. I was never given a notice of hearing at the start, so then therefore no hearings can therefore be based on the first order of tribunal on 25 October, and you can check that for yourself, but that is the truth. So by making the first order of tribunal on 25 October 2022, Mrs. Merritt breached section 92.
McDonald, the hearing today is your chance to raise matters that you want to raise. I won't be going through what is 2,000 odd pages of file and addressing all of the points that you've raised. If you want me to address anything, you need to raise it today. I'm going to address these two matters that you've raised. The first is the promise to tell the truth. Now, the tribunal does have an ability to require witnesses to give evidence under promise. Whether or not we're going to hear any witness evidence today, I'm not certain. But the district court has confirmed that the tribunal should not put the parties, so that's you and the landlord, on promise, because the promise only relates to evidence that's given at the proceeding, not submissions. And what the district court said is that if parties are to give submissions, then they cannot give that by way of a promise. They can only give evidence under promise.
I have looked up the definitions, and I'm pretty sure that evidence is broader. I think it just means anything that we say. Yeah.
All right. Well, your request to have evidence put on promise, I've noted that, and if evidence is given, then I'll consider whether to require that to be given on promise. But most of the talking today, I imagine, is going to be done by Mr. Clapham, who's legal counsel and a representative cannot give evidence, so there's no prospect that Mr. Clapham can be put on promise anyway.
Yeah, I know that's fine. I understand it's to the applicant party. He's just acting on their behalf, and I understand that. But nonetheless, they have, he is their mouthpiece. So what he says, they are responsible for because they've instructed him. And I also just want to say, because I know that, I mean, it's up to Jenny what she puts on the file for the adjudicators to access, but these people are not my landlords, and the burden of proof is on the tribunal to show that they are, and that burden has not been met by the applicants themselves, and I have been corresponding myself with my landlord, who is at the moment he has not appointed any intermediary to my tenancy, and he is the sole director of Homewood Real Estate Limited. Now, Caroline says that she owns the PM side of the business. Now, the PM side is one of a couple of subsidiary companies. She owns minor shares in both of them and is still not a controlling, she's not a director and she's not an authorised person. So she has authorised herself, and that's, as far as I'm concerned, not evidence that she is authorised by the landlord. I'm just putting on that on the record, but what I've said to Jenny, and it doesn't matter to me either way if it went on the file, but as I do not really regard this as a hearing, I'm not, I do not regard myself to be the applicant, and I'm just mostly going to observe. But another thing that I did request is that, so Dominic has written an awful lot of points, and he refers us to various appendices. Now, in her order of tribunal, Rebecca Morgan said that the evidence showed that I had unlawfully declined access. Now, that hearing wasn't lawful anyway, again under section 91, and so again the order of tribunal violated section 92, but actually she never opened any of Dominic's attachments, and literally none of the attachments showed the evidence that she quoted. She plagiarised, she didn't even direct quote Dominic, she plagiarised Dominic's memo and put it into her order of tribunal. So I just would, if there's another request, and honestly it's of no matter to me, I feel I'm on a strong legal basis here, but when Dominic refers to appendices that he claims prove his points, can he please be asked to quote from the appendices where he believes that the evidence shows what he says.
Okay, now look, I need to address a couple of those points you've raised. So you've submitted that no notice for the original hearing was given that complied with the statutory criteria. I can't decide that, Ms. McDonald, because if you considered that there was a problem in relation to the earlier orders, then the time to take that up was when those orders were given.
Now, I don't mean to interrupt, but I think it's important that I do, because I actually do know the law probably a bit better than most respondents. Not that I regard myself to be a respondent today. If I hadn't been given a notice of hearing, because sometimes they get sent to the wrong address or there's a mistake, then that's fine. It would have been my duty to ask for a rehearing for those reasons. But I asked for a notice of hearing many times and I was refused. So the notice of hearing was simply only to for the applicant to ask for access to my home so they could send a cleaner in to clean my oven. That was in the notice of hearing. What was discussed in the hearing was a whole lot of other stuff, and very, very importantly, that I should be evicted. So that eviction is a very important matter and should have been in a notice of hearing, and it wasn't. So you don't. I am under no. If section 92 was violated, then I have there's no legal duty on me to dispute the hearing.
Okay. The original notice of hearing referred to section 56, which is a termination provision in the RTA.
I don't think so. I don't think the original that was on about 12. The thing is that under section 91, the tribunal only ever fulfills subsection B. Under the law, it has to fulfil subsection 1, and it never does. So, and if we were to argue that point and say, well, it's my job to look it up, may I also remind the tribunal that I have been the termination of my tenancy has also been sought on the I think it's section 50A or something, 50A1 or something like that, which is the death of the sole tenant. So I'm not really terribly inclined to take those sections mentioned at all very seriously.
Okay. give you my reasons for that in writing in my decision, and if you disagree with it, then it will be appealable to the district court.
Okay.
Now, the next thing you've said is that this is not a hearing but a conversation, or certainly that's what you've said in communications.
Yeah.
It's a hearing. And we've notified it as a hearing.
Yes, you have, but I haven't received a notice of hearing.
The tribunal doesn't convene conversations for people to have. It's a hearing. Again, if you want to dispute that, it will be appealable. The other point you said is that Harcourts are not the landlord. The landlord is Russell Forward, and he has appointed an agent according to the tenancy agreement, which is Homewood Real Estate Limited. Mr. Clapham, who are you here representing today?
Homewood Real Estate Limited.
All right.
But he's never been authorised. He can't authorise himself. He's never been authorised. Caroline authorised him, and she authorised him to represent something else.
I'm satisfied that Mr. Clapham appears today by way of proper authority of the agent. And again, if you want to disagree with that, then it's appealable.
It's not my job to appeal something. It's the tribunal's job to obtain their evidence. One cannot be satisfied of something that is not evidenced. But again, I'm just more interested in what you two parties say to each other, because this is more for my interest than anything else.
Okay. So we're going to now move on, and we're going to hear these two applications. And the first application that we're going to hear is the application for rehearing. We can do it now. Well, I think we'll do this one first.
Okay. We acknowledge your earlier points about the scope of this hearing and the exemplary damages not being able to be sought.
Correct.
There was an earlier decision which dismissed some matters, and one of those matters that was dismissed said that the landlord's application for termination based on rent arrears was dismissed, and other matters were adjourned for a later date.
Yes. And they did mention exemplary damages wrongly, in my view. The original application that the landlord filed in relation to application 4402060 did not apply for exemplary damages. I'm not entirely certain where along the line that sneaked in, but the application only related to a termination on the basis of the failure to allow entry. Now, irrespective of all of that, Mr. Clapham, the adjudicator issued a decision on the 2nd of May that was a final decision.
Okay.
It carried with it a right of appeal, which you're now out of time to exercise. And there is no ability with an appeal to file it outside time. There is an ability to apply for a rehearing, but you're out of time for that. The tribunal does have some discretion, but in the circumstances, I can't see how the tribunal would exercise that discretion. What I'm saying to you is the ship sailed.
Okay, understood.
Exemplary damages. All right, so we're dealing with the application for rehearing. If the application for rehearing is successful, then what will happen is we will schedule another hearing to consider the matters that were before the adjudicator on the 2nd of May. If the application for rehearing is not successful, then the order for the 2nd of May continues to be in force. The stay gets lifted, so you get a possession order out of it, which is really...
Okay, I'll start with you, Ms. McDonald. Can you please state...
Okay. I think that's all understood and accepted. I think I understand that correspondence between my client and the tribunal confirmed that the application had been amended, and that seemed to have been accepted along the way by the tribunal.
All right.
But otherwise, we expect
that's the case. It might be the case. It doesn't get over the fact
we accept that
the 2nd of May decision is a final decision. Sometimes what a decision will do, like the rent arrears decision, it'll say, I'm deciding this part of the application, but we're going to adjourn this part, and we'll hear that another day. And that's exactly the situation with the rent arrears that we're going to go on and see. So the tribunal had declined to terminate the tenancy because of the rent arrears, but it said we're going to adjourn the question of rent arrears for another day. So that's fine. You know, it's a final decision as it relates to the termination. You could have appealed it if you wanted to do so, but there's still the outstanding question of the rent arrears. That's fine. The tribunal can go on and hear that today. But the 2nd of May order, there was no adjournment of any matters. It was a final order. Now, I have to ask at this stage, has possession of the property been returned to the landlord? Okay. The reason I ask that is if possession had been returned, then really that 2nd of May order would now be moot. But if possession hasn't been returned, then it remains relevant because there's a possession order that attaches to it. Right. Now, the question then becomes, has a substantial wrong or miscarriage of justice occurred, or is it possible that such a situation has occurred? And that's what Ms. McDonald says is the case. So, Ms. McDonald, do you want to tell me what substantial wrong or miscarriage of justice has or may have arisen?
Yeah, again, I've got computer problems. Do you have my application for the rehearing in front of you, by any chance?
Yes, I do. Would you like to work through those one at a time?
Yeah, I think that would be really helpful, thank you. Yeah, look, I've been having computer problems for quite a long time, and Jenny is aware of that, and I have actually asked for some information to be sent to me just because, yeah, I had massive problems. I spent $600 getting it repaired recently, but it's still playing up a bit, so that would be really helpful, thank you.
All right, well, that's no problem at all. I don't mind doing that. So what we'll do is I will read out the reason for the rehearing on the application.
That's great, and then I might be able to find more detail on my email on my phone.
Yeah, and then so what'll happen is there's 6 reasons here. I'll read it out.
Yeah.
Because Ms. McDonald is the applicant, Ms. McDonald, you then go next and you explain what you want to on that. So you make your submissions. Then I'll go to Mr. Clapham. Mr. Clapham can submit on that point. Then I'll come back to you, Ms. McDonald, and then we'll move on to the next ground for the rehearing.
Yeah.
Sound all right?
Yeah.
Okay. All right, let me just get my notes up to date. Now, the first ground for the rehearing is, and I quote, the tribunal on several occasions failed to comply with Section 91 of the Residential Tenancies Act 1986 for the hearing which was held on 25 October 2022. Accordingly, there was no lawful basis to hear and determine the matter on 25 October 2022 and no lawful basis to adjourn the matter as per Section 92 of the Residential Tenancies Act. As such, it was unjust for the tribunal to rely on this order and making the order on 2nd May 2023 as it did. So, Ms. McDonald, what do you want to say to me in relation to that?
I think you and I have had that conversation, and I'm not being facetious. I'm just saying that I was not given a notice of hearing for anything but access to clean my oven.
And that's the original application you're referring to as, oh, sorry, for the original
Yeah,
hearing.
the original notice of hearing. And it was very clear from the application that's what they wanted. They wanted an order of tribunal so that the cleaner could come in to clean the oven. And that's a big story, but although it was a false claim, nonetheless that was the claim that I was prepared to hear. Now, on 20, now bear in mind that I think the application was filed on 12 October by Diane Colgan, and they just wanted to get access to clean my oven, which I was denying because cleaning it wasn't a remedy for the disrepair that it was in, and the cleaner herself said I can't clean rust. But anyway, that was what I was prepared to turn up to the tribunal to easily refute. But bear in mind that the hearing was set for 25 October, so that's 12 to 25 October, that's plenty of time to shoot fish in a barrel. On 20 October, which was I think Thursday or maybe Friday, the day before Labour weekend, Diane Colgan directly emailed Jenny asking to it was put through as additional information, but it was not additional information. It was a separate claim to terminate my tenancy, and no reasons were given. I asked for an amended notice of hearing because I really don't think that 3 working days was long enough for me to prepare to defend that. And I wanted notice of hearing. I wanted to have the reasons given. Diane Colgan would not. She said we'll discuss it at the tribunal, and I said that's not fair because I should know ahead of time what we're going to discuss at the tribunal. Now I was in a state of mental breakdown at that time, and that's a different matter, but that's a different matter that I'll bring to the tribunal and maybe criminal courts later on. I asked for an adjournment considering that very late edition that was did not meet section 91 whatsoever, and actually it can't even be claimed that they just wanted to terminate my tenancy because I wouldn't let the cleaner in, because I did not attend that hearing for very good reason, because I knew that I could not cope with 3 bullies who were trying to get me out of my tenancy. And so the order of tribunal actually very clearly showed that matters completely different than the ones that were notified were discussed. So I feel that section 91 being breached or section 92 being breached, there was no onus on me to ask for a rehearing, because as I say, I think for a rehearing for a lack of notice of hearing, like that's happened before, like if someone just gets sent a notice of hearing to the wrong place, or if there was an error. But I asked repeatedly for an accurate notice of hearing, repeatedly, and it was repeatedly refused.
All right.
So that's not a matter for a rehearing. That's a matter of, sorry buddy, but that's section 92 is breached. You cannot. That order of tribunal is void.
Thank you, Ms. McDonald. Mr. Clapham, what does the landlord say?
So in respect of sections 91 and 92 of the Act, Ms. McDonald appears to suggest that the tribunal failed to follow the statutory procedure regarding providing of notice, and therefore the tribunal was not able to issue its decision of the 2nd of May.
No, I'm talking about October, 25 October.
Yes. I think what this means is that the original hearing was flawed, and because of that, all of the subsequent matters equally flawed, up to and including the 2nd of May 2023. So when they not clear what was not that much more than the description, nor the provision, the statutory breach, nonetheless, it is suggested significant Ms. McDonald did not receive the notice of the hearing, and there is no evidence of that being the case, and this submission is today suggests that she would notice. There can be no evidence to the tribunal's ability to hear, determine, dismiss the matter. In respect of the hearing on the 25 October 2022, it's clear from the tribunal's order on that same day that the matter was adjourned for the benefit of Ms. McDonald. For the avoidance of doubt, it is acknowledged that Ms. McDonald was the respondent on that day and in relation to that application.
I just need to say one thing, Dominic. Sorry to interrupt you. Just a point of fact. I didn't claim that I didn't receive a notice of hearing for the 25th October hearing. I claimed that I received a notice of hearing for an order for access to clean my oven. But what was in the order of tribunal was about what was discussed in my absence, which was terminating my tenancy for other reasons. I did get a notice of hearing, and I was prepared to turn up to that hearing and shoot fish in a barrel because it was false. I could have also refuted the rest of the claims that were made and totally secretly from me, but I asked for an adjournment because of three working days notice of a new claim, not additional information, a new claim, and that adjournment was declined. It's entirely unreasonable, but carry on.
So in the Tribunal's order of the 25th of October 2022, the Tribunal did not terminate the tenancy, including but not limited to the reasons given at paragraphs 9 to 10 of that decision, including the following. It appears that Ms McDonald is suffering health difficulties, and this may well be a significant contributing factor in the manner in which she is communicating with the landlord. Taking into account the particular circumstances here, I consider that it would not be equitable, open brackets, fair, close brackets, to terminate the tenancy today.
Can you read the order, the notice of hearing?
Ms McDonald, I'm going to stop you there.
I'm sorry, I apologise.
Please don't interrupt Mr Clapham. What's going to happen is...
I apologise.
Once Mr Clapham has made his submissions, I'm going to come to you then and invite you to say anything final that you want to say.
I was in the wrong. I apologise to Mr Clapham and to you.
No problem, Ms McDonald. Thanks for that.
Okay, thank you. Insofar as the applicant submits that the Tribunal breached Section 92 of the Act in respect of its ability to adjourn a matter, the respondent submits that Section 96(1) of the Act is equally relevant. This section provides that, quote, the Tribunal may adjourn a hearing at any time and from time to time and place to place upon the application of either party to the proceedings or of its own motion and on such terms as it thinks fit, end quote. It is accordingly submitted that the Tribunal had the jurisdiction to issue all the orders that it handed down in respect of the applications between the parties to this application, and no grounds for rehearing arise. And we've just pulled up the notice of hearing for the 25th October date, and the remedy is, sections quoted in that notice include section 56(1)(a), which is the section that application was made under and defined on. And no further submissions on that point.
Okay, thank you, Mr Clapham. Ms McDonald, I'm coming back to you now for any final comments on this point for you.
I think the points I've made as you said at the beginning, and I'm not saying that this is what you had in mind when you said so. This is far simpler than the other party is trying to make it. I just did not get a notice of hearing. I did get a notice of hearing, but I did not get a notice of hearing that gave me any chance to respond to what was actually the contents of the hearing, and that's simply a matter of record. It's a matter of record. It's not opinion. The records are held on file. That's all I've got to say, and I'm happy to move on to the next point.
Okay, let me just catch up with my notes, okay? What I should tell you all, and I should have said this right at the beginning, as we go through, I'm not going to give an indication of how I view all of these matters. When the hearing's finished, I'll be going through the information I've got, and a decision will be issued in writing.
Yeah.
So, look, just don't expect me to give an answer today.
Oh,
Right.
yeah, totally.
Okay. So the next ground for a rehearing, and I quote, the tribunal and or the adjudicator fails to comply with Section 65 and Section 66 of the Human Rights Act 1993, amounting to an unjustified limitation on the applicant's rights as per Section 19 and Section 27 of the New Zealand Bill of Rights Act 1990. What do you say about that, Ms. McDonald?
Yeah, so I was at the time, I have never managed to find any representation, and I'm a very isolated person, and I've been in Christchurch for a year, and I have been uphill, down dale, trying to find. The thing is that it's not so much that I need help to represent myself. You can see that I hope I appear to be a clear and confident communicator. That is not the problem. The problem is that I have neurocognitive brain damage. It's an actual brain damage. It's not psychiatric. It is caused from chronic stress, which is usually occurs after 6 months of unrelenting stress, and in my case it's been 19 months. I don't want to get it too technical, but it's overuse of the prefrontal cortex, which is used to dealing with novel situations and problems. It's not supposed to be running 24/7, and when you get adrenaline rushing through the blood-brain barrier constantly, you end up producing, I think, more white matter and less grey matter or something like that. Anyway, so my thought processes, although I can speak very confidently on things that are in the front of my mind, my working memory is quite poor. So I've been absolutely unable to put together all of my evidence. And it's what it feels like is I remember as a teenager playing Doom, one of those sort of shoot 'em up games, and you could walk around and the graphics were so bad, and I would often go wandering around trying to look at things more closely, but the if I walked up to a wall to have a look at the detail of the wall, it would just become very pixelated. And that is a very good analogy for what it's like for me when I try to focus on preparing the huge amount of information that I have. Now, you do refer to the huge amount of information that I've sent. Now, the reason it's a huge amount of information, that's cause and effect. I have so much evidence against the applicants because that's what I do. I keep evidence, but the matter of organising it in a way that, unlike Dominic, I don't have a unlike the applicants, I don't have a lawyer, and unlike the lawyer, I don't have a paralegal or a law clerk or anything like that. And so ADL, Auckland Disability Law Centre, I approached them, and so my disabilities meet criteria, 3 criteria under Section 21, is it 21A or something of H or something of the Human Rights Act. And my doctor's written a letter to say that I am cognitively disabled. A psychiatrist wrote that because I have PTSD. The thing is that I just cannot perform on the same level as essentially 6 industry professionals. And I have chronic fatigue syndrome as well. And with chronic fatigue syndrome, mental exertion has the same impact as physical exertion, and they both cross over and affect each other. And so there have been times when I have not even been able to get out of bed. I haven't been able to do my dishes. I'll have a shower with basically a bottle of warm soapy water. I can't do what Dominic can do. And so accommodations were asked for by my ADL advocate, and they were declined. And that was really unreasonable. And to go, I think the next point, and this leads into the next point, is that I did not have counsel, and ADL had asked Mrs. Merritt, could we please adjourn all hearings until we managed to find a legal representative for Caitlin. Now ADL is an office of 3 solicitors, 1 receptionist and 1 manager, so they don't take clients on. Now Dominic has referred to Toby Cooper as my counsel. He was never my counsel, and he was never actually my representative. Now what happened was the first advocate, Adelina Lotto Malasea, had written, as I say, to Mrs. Merritt, saying, can we adjourn for about a month to give us a chance to place Caitlin's profile on the Tiara Ture, pro bono clearinghouse, so she can get adequate assistance to prepare her case, because it's not representation, it's the preparation, right? And get them, that lawyer, up to speed with Caitlin's situation, because you can't just get a lawyer to suddenly come in and represent you. And that's actually what ended up happening, which I'll get to in a minute. And so Adelina made 2 requests, which were, I think, quite clearly intended to be taken together. I don't understand how they could be separated. And then she said that she would like to balance the power difference, which you can see in front. Well, you can virtually see in front of you today the imbalance, right, of the 2 parties. So there was just she asked under, I can't remember which section it is, but it would be quoted a bit further down, that she asked, because adjudicators can in some situations grant counsel to representation to one side to even out an imbalance. But what Mrs. Merritt did was she declined the adjournment time, but she granted me counsel. And she said because she granted me counsel, she can therefore grant the other side counsel, like representation, which was irrelevant to the section. It defeated the purpose of redressing the imbalance. And secondly, she misquoted that section, that subsection. It's not, the other party may have representation if the first party has representation. It's not if they've been granted representation. Having been granted representation for a hearing the next day was of absolutely no benefit to me whatsoever for my disabilities. Now, and then what happened, everyone seems to think that Toby Cooper was my lawyer. They were really concerned for me. Toby was busy on his own stuff, and he doesn't know the Residential Tenancies Act. He didn't know my case. Now, Rebecca Morgan stated that Toby represented Caitlin capably. She has no grounds on which she's got no grounds on which to make that claim. She couldn't possibly make that claim. I lost that hearing because Toby didn't know the RTA and he didn't know my case. We had a conversation for 2 hours the day before, and I would have actually been better without representation, because Toby didn't understand my situation, right? So I won't go on about it, but you can kind of see how I would have been better off if Mrs. Merritt had said no to the legal counsel, legal rep, than I would have been before the request, which was also a huge disadvantage to me.
Okay, thanks. Oh, sorry, carry on.
Yeah, no, sorry, I do have a tendency to ramble. I do have ADHD, and I apologise. I take Ritalin, but it's not a cure, it just helps a lot.
Okay. Mr. Clapham, what do you say in reply?
Thank you. So insofar as the hearings for this matter are concerned, the applicant has attended 2 hearings, one in person on the 16th of March 2023 and one by telephone 27 April 2023. The applicant's solicitor was also in attendance by telephone on the 27th of April. At each hearing the applicant has attended, she has been afforded every opportunity to present evidence and submissions in support of her position. Indeed, at the hearing on the 27th of April, the adjudicator allowed a mid-hearing adjournment for the applicant to prepare and make further submissions in support of her case, notwithstanding the fact that the applicant had had time to advance her response to the respondent's claims. It's also not clear what makes the applicant allege she is a whistleblower or other such things contemplated by sections.
I'm unable to hear. Dominic's cutting out for me.
Okay. I'll move
Do you want to just rewind a bit there, Mr. Clapham?
Yes, certainly. I'll go back to the paragraph before. Indeed, at the hearing on the 27th of April, the adjudicator allowed a mid-hearing adjournment for the applicant to prepare and make further submissions in support of her case, notwithstanding the fact that the applicant had had time to advance her response to the respondent's claim in that matter. It is also not clear on what basis the applicant alleges that she is a whistleblower or other such person contemplated by Section 66 of the Human Rights Act. Additionally, Section 66 of the Human Rights Act requires that a person who is defined as B in the section is or seeks to make use of or comply with the Human Rights Act, not another piece of legislation, for example, the Residential Tenancies Act. Again, it is not clear from the applicant's application for a hearing what rights under the Human Rights Act she seeks or sought to make use of. In any event, it is submitted that the respondent has not treated the applicant any differently because of her alleged attempts to enforce her rights, if any, under the Human Rights Act. And the respondent accordingly submits that no substantial wrong or miscarriage of justice as contemplated by Section 105 of the Residential Tenancies Act applies, and therefore the grounds for a hearing are not made out. And that's all the submissions on that point.
Okay, thanks, Mr. Clapham.
Oh, sorry, there was one further. At one of the hearings, it may have been the 16th of March hearing, Ms. McDonald was in attendance with two support people. My client offered to deal with Ms. McDonald through those intermediaries, and those offers were declined. So all attempts have been made to assist Ms. McDonald in communication and assist her through third parties, but they have all been declined.
Okay, Ms. McDonald, back to you for final submissions on this matter.
Am I able to make a final comment on that?
Yes, of course.
Oh yes, thank you. Yeah, just again, I just want to, we're using kind of counsel, solicitor kind of for these purposes pretty much interchangeably. Again, Dominic insists on calling Toby my solicitor. Toby was not my solicitor. Toby is a solicitor. And he made it very clear to Dominic and to the tribunal, and Dominic, I told Dominic, can you stop contacting Toby please, he is not my lawyer, he is very busy. Now Dominic would not take my word for it, and he emailed Toby saying, are you or are you not Caitlin's lawyer? And Toby wrote back very clearly saying, no, I am not. My role is limited to making the initial advocacy and making the submission. And he said, we have no role in Caitlin's Caitlin's case. They simply can't. There's three of them, and that was also clarified to the tribunal as well. And what was the other point? Yes, I was. So I'm not sure what Mr. Clapham is meaning about other legislation, but the RTA explicitly mentions the Human Rights Act and says that it's forbidden to discriminate against anyone on any grounds, and the Human Rights Act prevails anyway. I mean, I don't mean it's going to prevail in every situation, but the point of natural justice, which is the focus of the Tenancy Tribunal, it would be impossible to say natural justice occurs when an experienced litigator goes head to head with a woman with cognitive, like literally neurological damage, and no lawyer. And on the point that he raised about Caroline and Courtney offering to talk to my support people, that is blatantly discriminatory. I have no inability to understand information, and my support people was a friend I'd met in the psychiatric hospital, where initially it was thought that I had a mood disorder, and then it turned out I just had a PTSD, which explains a lot of my what Dominic frames as unpleasant or erratic behaviour, because that's what PTSD does, and it took a while to differentiate a mood disorder from a trauma response, and therefore I was released from the Mental Health Act. And so I had one other poor soul who was there, just couldn't do much for me, and she's got her own stuff. She's got a daughter. She's and the other person was there were two people from MAPS, the Mental Health and Peer Advocacy, and unfortunately they're of no use legally. They were just there for moral support, because I did not want to face the people who had been bullying me into two suicide attempts, which landed me in Hamilton in the first place. So they were just there as buffers for me. They had no ability to understand the law, to communicate the law, and they are stretched molecule level thin. They are a social service that is entirely charitable. They were doing a great favour to me just to be there for me that day, but they can't help me.
Okay, thanks, Ms. McDonald. Moving on to the third ground, and I quote, "The tribunal disregarded relevant considerations and took irrelevant considerations into account, including that in order to terminate the tenancy was made before evidence arising from relevant cross-application claims by the applicant could be considered, and that the tribunal failed to give appropriate weight to the wording of an order of the tribunal made on 16 March 2023.
Yes. Now I'll go to the second bit, the wording of the order. Now, and I'm doing this from memory. I do appear to have changed my mind about participating, so I haven't done any preparation. But as I have said to the other party, it's easier just to keep your story straight when you're just remembering the truth rather than inventing it. So I will just work to my memory to the best of my ability. So what was that the second point you made? I was going to respond to. Oh yes. So
read it out again?
Yeah. No, that's okay. I remember now. Okay. So Mrs. Merritt on the 15th, on the 16th, she had, sent us her order of tribunal, and she was giving me. I mean, it's not fair anyway, because I've never on any occasion disallowed entry to the landlord lawfully. I've disallowed entry to the landlord plenty of times when the entry was unlawful, in which my permission would have had to been given, but never unlawfully. But that's just context. But nonetheless, based on what Mrs. Merritt had believed of the situation, and I have to say, I think based on what she believed, she was being quite kind to me, and she said, you have this final chance to let the landlord give the landlord entry under circumstances he is entitled to, he being his representatives or whatever. And I of course agreed to that. And so the thing is, there are 2 points here. One, lawful entry, and the thing is that if Mrs. Merritt had written in her order, let the landlord in any time he wants under any circumstances, obviously that would be unlawful, because adjudicators cannot order unlawful acts. So it was clearly lawful entry. And the second bit was, the entire purpose of this was to give me a clean slate to redeem myself as she felt that I needed to redeem myself from the period of the issue of the notice of hearing. And when the adjourned hearing came about, it was not Mrs. Merritt but Rebecca Morgan who took the case, who took the hearing, and I jotted down a few points, and they're not in front of me right now, but I do remember that firstly, so Dominic started, and she asked Dominic to start, and she asked Dominic to start again as if she knew nothing from the very beginning, and it's like, no, this concerns the 16 March onwards only, because Mrs. Morgan had already made a determination about the preceding time frames, and the very purpose of that was to let me redeem myself. So Ms. Morgan had written in her order of tribunal that she is not persuaded that my new compliance with the with what she felt was the laws that I had breached. She didn't feel that was a genuine compliance. She felt that it was only because I knew my tenancy was at risk. But that was the entire basis of the adjournment and the chance I was given, do you see? So she was, I'm really not sure. I don't think she read the I don't know how adjudicators get the, adjudicators that come into an existing case, I don't know how they get their information, but she seemed to be very mistaken on what she was supposed to hear and decide on. So she decided on something that wasn't to be decided. What was the first part of the my objection? If you don't mind, read it to me again.
No, I don't mind at all. The tribunal disregarded relevant considerations and took irrelevant considerations into account, including that in order to terminate the tenancy was made before evidence arising from applications.
And this has been really key for me. Okay, so I think there was a bit of confusion, and it's possible that the confusion is caused partly by myself. But again, it's kind of like that balance of sort of likelihood or probability or what's reasonable. But when I was having great difficulty in putting my cross application together, but I did cross apply. Now these were not separate. I know that cross, and I think this is where maybe my fault comes in, because I have read about cross applications before. I've never made one, in which a cross application can be, well, I also want to raise these other topics, but I didn't do that because I couldn't possibly, and I made it clear to the registry that I will have to make my own claims against the applicant later on when I was capable of doing so. All I wanted to do at that point was to save my home. So my cross application was simply a refutation of the claims made against me. And I believe I made it clear enough that those were the claims. And I did actually spend $203 bringing extra information to the hearing. Now, you do acknowledge, as I freely admit, that the information that I presented there's a huge ton of it, but that is evidence of the fact that I am cognitively disabled and I've had no one help me put it together, and I've done my best, and the registry does have improved copies of information that I sort of dumped. It's not new evidence, but it's when I've just tried to order it a bit better and put some explanations with it. And I had put quite a bit through before, because I've got every, like, a paralegal could put it together and just show you instantly that the other side's claims are totally baseless, and deliberately untrue because I have the records in their own words, but I just couldn't put it together in a cohesive way. So I did give a bunch of information in my application on the 7th, which was, I tried really hard to do that so in order that it could be heard at the same time, which was the purpose of a cross application, that you can hear them at the same time ideally. So I got it in on time. Now Mrs. Merritt for some reason shuffled everything around, and she sort of changed so we have two numbers for each of the applicants' claims, and they refer those refer to specific, those application numbers. Application numbers are short, they're short labels for a bigger piece of information. But what Mrs. Merritt had done is change the two into, because one of the claims was for my termination for not letting lawful access and exemplary damages. So there was an action claim and a financial claim under one application number, and on the other one there was again the second claim was for an action order and a monetary order, and that was for rent arrears, and both of them were eviction claims. Now I was told that by the registry that Mrs. Morgan would, and this was only the day before I believe, has changed her mind, and she's going to hear on the 16th only the landlord's application for termination, and she would hear my claims another time. But they're not my claims, they're directly relevant to, they're my responses, and at the same time I was claiming exemplary damages for false attempt to terminate, which I proved. But she didn't hear my evidence because she characterised them as separate claims. And I also got back to the registry, and I know that it's not Jenny's decision herself, she's just passing on what Mrs. Merritt said, but I said I'm really confused what Mrs. Merritt means by the applicant's claim to evict. They've got two claims to terminate. Which one? And then Mrs. Merritt came back with the applicant's claims to terminate. And so what happened was, and then she said the respondent's claims will be heard later. So I was hogtied because she had artificially narrowed the scope, so I couldn't bring in up many of my points. And I had spent, as I said, $203 that I had to borrow from my neighbour because I'm on supported living payments because I am very, very, very unwell. I can't work, let alone do all this stuff, this is a full-time job. And Mrs. Merritt wouldn't look at any of it. And so her order of tribunal completely failed to take into account the hard proof that I had that the other side was making inaccurate claims. And I won't call them lies because that's for another time, but simply for refuting their claims, the evidence was not looked at, and to this date it has not been looked at. So so for that termination claim, and it's an unlawful claim anyway, for reasons I've given. The applicant has been heard about 4 times their side, and my side has never been heard. So that's what it means that Rebecca Morgan failed to take into account the relevant information, because again I'm hogtied. I'm not even saying hamstrung, hogtied. And then she entertained Dominic's introduction of new subjects, which were that I said later to Dominic, I said, look, that needs to be for an antisocial behaviour claim. You know, it's got really nothing to do with the matters at hand. Nonetheless, Mrs. Morgan took his word that I was difficult to deal with and said that given the animosity and that she appeared to believe was caused by me, that was also a ground. But that was not a ground for discussion. Dominic introduced it, and it was just I just really noted that it was and the adjournment that I was granted was 10 minutes basically, and it was just Toby and me going, you know, like she would not let me. She kept me on a very straight and narrow path, whereas she gave Dominic the floor to talk about quite irrelevant topics. And that's all I have to say.
Okay. Mr. Clapham.
Thank you. We may just respond in order of Ms. McDonald's submissions just now. In respect of not allowing access and Ms. McDonald's refusals, the tribunal has already satisfied itself that the refusals to allow access were unlawful and were in breach of the Act, and the timeline set out in the orders, which we won't run through again, supports this to be the case. We're not entirely sure what the submission in respect of Ms. Morgan should have looked at the 16th of March timeline only. But the question was posed of Ms. Morgan to what extent she would like us to set out the background. She asked that we set out from the beginning, and so we did in a very brief manner. And in respect of the hearing and what Ms. McDonald described as being allowed another chance or a clean slate or something to that effect, prior to the eventual access being granted, there had been a further refusal of access, and Ms. Morgan was satisfied that there had been a further refusal of access, and that the subsequent allowal or the granting of access would not outweigh the previous refusals. And Ms. Morgan noted that she was satisfied that there would be ongoing issues with the tenancy if the tribunal was not constantly involved in the matter. So those were her concerns, and her decision followed. Not entirely sure on the cross-application submissions either. However, Ms. McDonald was allowed to make submissions and present any evidence that she wanted to at all of the previous hearings. And as mentioned earlier today, a further mid-hearing adjournment was granted for Ms. McDonald to prepare subsequent submissions at the last hearing. Accordingly, Ms. McDonald has been heard at each of the hearings that she has attended. And in respect of Ms. Morgan allowing new subjects and the issue of Ms. McDonald being difficult to deal with, the submissions that were made on behalf of the landlord in that regard were in response to Ms. McDonald's submissions that the tenants, that the relationship between her and myself had grown to be a positive one, and we made submissions in response to that, raising our concerns, and those concerns were validated today, and the tribunal's order followed that as well. And so I'll just refer to written submissions now as well. So Ms. McDonald appears to be asserting in order of termination of the tenancy, the adjudicator made a discretionary decision, and that the adjudicator's decision was flawed. We know the Supreme Court case of Consent and Bashir, which confirmed that a general appeal is to be distinguished from an appeal against the decision made in the exercise of discretion. And while the respondent acknowledges the use of may in Section 56 of the Act, this does not make the tribunal's decision discretionary. Rather than having considered the evidence and submissions of the parties, the tribunal issued a decision it was entitled to issue in accordance with the provisions of the Act. And if the respondent is incorrect that the tribunal's decision was not discretionary, which is denied, then the applicant's application does not contain any detail as to what relevant considerations were disregarded and what relevant considerations were taken into account by the adjudicator. In any event, we responded to the applicant's further details today, which don't raise any issues as to discretionary decision regardless.
Okay.
However, it is submitted that the adjudicator appropriately and carefully considered the evidence put before her. Accordingly, we have responded to the applicant's further submissions. And there is a further district court decision of low inquiry. And briefly, I'll read this extract out. Quote, rehearings are about challenges to processes and procedures and are not about what the adjudicator found or the decision the adjudicator made, end quote. And it's likely submitted that the grounds for a rehearing have not been made out.
All right. Thanks, Mr. Clapham. Anything final from yourself, Ms. McDonald?
Yeah, just repeat a couple of points again that I think Dominic has. I've already sort of pre-refuted Dominic's points, and I just want to briefly make those again. We just need to refer to the order of tribunal made by Robin Merritt. There is no reason for me or the applicant to believe that the order of tribunal was not. I don't think Mr. Clapham can have it both ways, to say an order of tribunal is binding in one case but not in the other. Mrs. Merritt's order of tribunal, which any of us can read right now, very clearly states the reason for the adjournment, which was to give me a final chance to reform my ways, and she has previously acknowledged my poor health and so forth. So whatever the reason that Mrs. Merritt wrote that order of tribunal, which we can all read, nonetheless that was what was supposed to be discussed. Once again, the adjournment that Dominic makes much of that I was allowed, again, was 10 minutes. Okay? And Ms. Morgan did write that the respondent me had stated that her relationship with Mr. Clapham had become positive. That's not how I phrased it, I believe. I won't say anything personal about Dominic today, but I said plenty personal to him, and he knows how I feel about him. And but what I did appreciate is that it looked to me like the landlords were reforming their ways. So rather than sending the owner of the property, the landlord, who told me he was a builder, but and he may well have been a builder, I don't know, but he is not and has never been an LBP, licensed building practitioner, because I've checked the register and I've worked in those areas. So whatever he's been doing has totally failed. So I gave him loads and loads and loads of rope at the beginning. And then I just started to get really fed up with this constant invasion of my quiet enjoyment, because I'd just bloody moved into this house that had many problems with it, and I was going through a hugely stressful time because my movers had fallen through and I had to arrange more movers so I could. It was just a really stressful time, and I was like, look, I am not tolerating this anymore. Every repair that Russell has made has immediately failed or made the problem worse, and I think that's evidenced by the fact that when Dominic came on the scene, I honestly, like, I'm a bit gullible, And I thought that it was a sign of good faith on the landlord part that my requests for, proper experts to attend the repairs, because that's Homewood says the landlord is entitled to do all of his own work. That is totally untrue from a legal perspective, and there is some work that Russell has been doing on the house, not just regular electrical work which you can do only in your own home as an unlicensed, not as an electrician, but he's actually been doing prescribed electrical work which is forbidden except for a licensed electrician. And I was really starting to worry about the safety of this place, and there were many safety concerns. And the fact of the matter is, when Dominic started arranging real repairs people to come in and finally fixing Russell's problems, and I recorded, I didn't record the people, but I noted and I recorded back to Dominic what had happened during the visit, and I had photos and everything. Like, Russell had put a blind up for me, and the handyman who was an LBP but was just sort of taking a career, taking his career easy, but very experienced. He took the blind apart and he was like, what the hell? There are screws in here that are preventing the pulley from working. There's glue. There's a bracket that's on the outside rather than the inside. So there were points that Dominic had insisted that Russell came in to do work, which he said that I'd refused. There is a quote that was made in Ms. Morgan's order of tribunal from me, and that is my quote: therefore no one is allowed access to my home today or tomorrow or something. Now, that does not, remember that the RTA doesn't say that the tenant can't refuse access. The RTA says the tenant can't refuse lawful access. It was not lawful access. I was trying to find out what it was that Russell was going to do. Now, eventually I said, okay, Russell can come in and do these things. He did not one single one of them. And so that's when I put my foot down and I gave a 10-day notice, and Dominic actually started bringing in proper people and things were done. This has included light bulb changes, and the only reason I couldn't change the light bulb myself is that it's one of those ones that requires unscrewing the fixture, and that really requires a ladder, and it becomes a health and safety issue under WorkSafe regulations, where you need a PCBU, and that's not, tenants do not have to carry out any work that endangers themselves. Russell couldn't even do that. So literally nothing was done. So when I refused access, I'm like, again, I don't have time for this bullshit. And it was really just a bit of a setup. But Mark, a lot of work had been done, and I had documented that in detail to Dominic. This was included, and I was really thankful to Dominic. And even though Dominic and I do not like each other one bit, I have the ability, and he appeared to have the ability, to have a functional working relationship in which we could be very civil with each other whilst we arrange these repairs to occur at my home. And so most of those repairs were done, and I was incredibly grateful. So the quote that when Dominic said Ms. Morgan had carefully considered the evidence, I've already refuted that. She literally did not open any of his appendices. She lifted a quote without even showing it to be a quote, so that is plagiarism. not that plagiarism comes under the RTA as an offence, but Dominic wrote the applicant had said, therefore no one is allowed access. And this is because I wasn't given proper notice and I didn't know what the hell Russell was supposed to be turning up for. But I eventually did let him come in and he did nothing. But yes, I did say that. But there is no law that says I have to allow access of any sort. And the fact that the context, the conditional was elided from the quote is very suspicious, because it started with, so not therefore, it started with so. And so why would Dominic quote the second part, which is implicitly follows from the first clause? And so Rebecca Morgan literally just lifted that quote from Dominic's memo and put it into the order of the tribunal, and she actually made a stronger claim than Dominic had made. Dominic said counsel notes, whereas Rebecca said the evidence shows. Now, none of Dominic's appendices contained that quote. I don't think there was any care whatsoever when she made. I think she just decided to not bother looking at any of the evidence, and certainly none of my evidence was taken into account.
Okay.
And that's it.
Rightio.
May I say?
Oh, when you say that.
Just go like 2 minutes to go to the toilet.
Oh,
I've been sitting here for half an hour even to go. That's all I have to ask.
okay. We'll pause for 5 minutes.
Okay.
And, Ms. McDonald, are you going to stay on the phone, or do you need to get away from the phone?
I don't know, I might take you to the toilet with me.
Alright.
No, I'm fine, I'm just going to stay here.
Okay, well, if Ms. McDonald's going to stay on the line, you go,
Yep.
and Mr. Clapham and Ms. Brown, you can stay in the room if you like, as long as Ms. McDonald's... Oh, you go, but as long as Ms. McDonald's on the phone. Oh, actually, everyone's heading out, Ms. McDonald. So what I'm going to do is I'm going to head out as well.
Okay.
You can just stay on the line.
Yeah?
You go. I'm going to go out too, and my registrar might need a break. Let's have 15 minutes.
Okay. Would it be a good idea to just have another phone call?
Yeah, that's okay. All right, we'll phone you back at 11:15. Okay.
Okay. Thanks.
So, Mr. Clapham, I'll get you to go out. We'll close the door and we'll bring you back in after we've got Ms. McDonald on the phone. Okay. Great. Okay. Well, thanks everyone. We'll see you in a quarter of an hour.
Thanks, Mr. Woodhouse. See ya.
Bye bye.